be seated. Now, I referred to the comments I made last Wednesday about Commissioner Owen's absence from hearings. Commissioner Murphy and I will continue to conduct the hearings pending Commissioner Owen's recovery. Commissioner Owen will listen to the evidence and or read the transcript of it. The parties will be advised if Commissioner Owen has any questions arising from the evidence. Thank you. Now, Mr. Ord, would you please come forward? Remain standing, Mr. Ord. Would you like to take the oath or the affirmation?
Oath.
The oath. Then please state your full name for the record.
Right hand, yes?
Yes, that's right, right hand.
I, Duncan St John Beresford Ord, swear by Almighty God that the evidence I shall give this Commission shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Ord. Please take your seat and make yourself comfortable. Yes, Ms. Segwit.
May it please the Commission, since Mr. Ord's last gave evidence, he has two more witness statements that I will now proceed to tender. Mr. Ord, since you've last attended, you've prepared two more statements, and there should be two in front of you. Could I ask you to identify the one with the number in the top right-hand corner, DLG.0001.0003.002?
Yes?
And is this a witness statement you have prepared dated on the front cover 22 June 2021?
Yes.
If I ask you to turn to the back page, that's your signature on 23 June 2021?
Yes, it is.
And it has 60 paragraphs?
Yes, it has.
And are there any corrections you wish to make to this statement?
No.
And is the contents of this statement true and correct to the best of your knowledge and belief?
To the best of my knowledge and belief, yes.
Thank you. Commissioners, I tender the witness statement of Mr. Ord, signed 23 June with the reference DLG.0001.0003.002.
Thank you. The witness statement of Mr. Ord will be an exhibit in this commission bearing that number. Thank you.
And there should be another statement in front of you, and that should have the number in the top right-hand corner, DLG.0001.0008.001.
Yes.
Confusingly, that's also dated 22 June. Could I ask you to turn to the back page? And is it signed on the 23rd of June?
Yes.
And if I could ask you to turn back one page, it has 63 paragraphs?
Yes.
Is that correct? And are there any corrections you wish to make to this statement?
No.
And is the contents of this statement true and correct to the best of your knowledge and belief?
Yes.
Thank you. Commissioners, I tender what is the third witness statement of Mr. Ord, dated 23 June, with reference DLG.0001.0008.001.
The statement of Mr. Ord will be an exhibit bearing that number. Thank you, Ms. Seward. Yes, Ms. Kay.
Please, the Commissioners. Good morning, Mr. Ord. We established on the last occasion that you gave evidence that you became Chairman of the GWC on the 1st of July 2017. When you commenced as Director General of the Department, you were provided with a briefing document by Mr. Connolly, weren't you?
Indeed, yes.
Pull that up, DLG.8001.0045.9601. Did you study that document at the time?
Yes.
Did you analyse it from the perspective of information that it should contain that it did not?
I took it for face value that it was a briefing for preparation for me joining Gaming Wagering Commission.
Did you think that it did not contain information that it should have?
No.
Did it refer to any matters or issues that you wanted to find out more about?
Look, I was aware I needed to learn a lot about gaming because it wasn't an area I was familiar with. I was also aware that the former Director General, Barry Sargent, was joining the Commission at the same time as a member rather than the Chair, and that I had discussed with him immediately prior to taking on the responsibility of being Director General of the new department, and consequently from that decision, the Chair, that I would draw on Barry's experience and he would guide me as a mentor through my early responsibilities on the Commission.
So I was asking you about the briefing paper, not a discussion with Mr Sargent. In relation to the briefing paper, did it contain any matters or issues that you wanted to find out more about?
I wasn't aware of any at the time, no.
Did the briefing paper raise in your mind any issues of concern that you thought required your immediate attention?
Look, I'd have to review the briefing paper again and make comment on that. It's a long time since I've read it.
Well, didn't you read it over the weekend for the purposes of giving evidence today?
I didn't receive it on the weekend, no.
Do you recall whether there were any statements or contentions within the document that you did not agree with?
I would need to review the document in full.
The briefing paper doesn't mention key performance indicators. Can I ask you about key performance indicators or KPIs? From your involvement in managing other government departments before you became DG of this department, you understood that key performance indicators of a department or a statutory body such as GWC, amongst other things, measure whether the entity is performing the functions and achieving the objectives expected of it. Is that right?
Yes, related to the budget appropriation and requirements of Parliament for that department, yes.
And KPIs measure whether a department or body is achieving those objectives effectively
It's one of the measures,
and efficiently.
and it's one of the measures of efficiency. There's obviously all the matters that you would include in an annual report, which goes to the heart of also KPIs are those. They are key indicators, particularly used by Treasury to assess the effectiveness of expenditure, but the actual annual reporting to Parliament, questioning and estimates and so on is used really to assess the performance of agencies, along with, of course, Auditor General's reports, which are comprehensively covering a lot more than KPIs.
KPIs are also used by the department itself and the body itself to which those KPIs relate to measure its own performance.
Indeed, yes.
And you understood, therefore, at July 2017, that framing KPIs that accurately reflect the functions and objectives for which an entity is established is very important. Would you agree?
Indeed.
And that KPIs should be kept under review by the governing body of an entity, such as the GWC, in order to ensure that the KPIs remain relevant and appropriate to accurately reflect the functions and objectives of the entity.
Yes, amalgamated departments such as the one I was to head up, of course, had a significant number of KPIs across a very broad range of activities. In the normal form of government, you would review critical ones where there was significant change, review those in priority and work through. To review every KPI in such an agency at the same time would be extremely difficult, given that the resources needed to do it particularly falls on a number of key officers.
You were the chair of the GWC come July 2017,
I was
weren't you?
indeed, yes.
And that wouldn't have been a task of the size that you are explaining now to review the KPIs of GWC, would it?
Well, it would still have required the same staff members of the department to work on that, because the department services the Wagering Commission. Also, the performance of RGL against its KPIs over a period of time have been consistent, so there weren't great variabilities. We were entering into a new period where the whole agency was going to be reviewed audit-wise by the Office of Auditor General, and the Office of Auditor General had indicated that one of their key areas they were interested in was progressive review of KPIs. So that was across the whole agency, so I was looking at it from a prioritisation of which ones we did in which sequence.
So is the effect of your evidence then that when you came into the role of chair of the GWC, you did not give immediate attention to the appropriateness of the existing KPIs?
I believe the KPIs were appropriate to the entity as it was, as I inherited it. It had had very good audit outcomes in the past from audits undertaken around its performance. So I had no reason to believe that they should immediately be addressed.
Based on what the Office of the Auditor General had previously said?
Well, from the audits that I was aware of that had been undertaken, though that changed obviously after we were going for some time, and OAG then suggested that we do review them.
Well, actually a year later in August 2018, not 17, when the time came to set the KPIs for GWC for the coming financial year, it was the case, wasn't it, that Ms Fiorentino, a member of the GWC, queried whether the existing KPIs were fit for purpose? She
did, and as part of our governance review as board members to discuss those matters, and she had been appointed with a new set of skills that the Gaming Wagering Commission hadn't had for some time, and she was very particularly interested in matters around the application of financial resources and so on.
Just asked you whether or not she queried whether they were fit for purpose.
Yes,
What's your answer to
yes.
that? What is your direct answer to that question?
She did query it,
Thank
and
you.
we agreed.
Well, you say you agreed. You didn't take any immediate steps to review the KPIs, did you?
Well, we had it on our list of things to do as an action item for the Commission. Those matters would be done by staff as we were able to do so.
Well, it's a fairly important thing to attend to if the KPIs are not fit for purpose. Would you agree?
Yes, I agree, and I certainly take responsibility that we weren't able to do it at that time. I did later bring the Auditor General into a conference because we were having difficulty to define with them. We did raise with them what changed KPIs might look like, and OAG had some views on this, as they did with many of our KPIs, and they weren't necessarily ones that were easy to meet, or some of the around how we collect data and so on.
Can we come back to Ms Fiorentino's querying
Yes.
the KPIs in August 2018, Mr Ord, which is what I asked you about?
Certainly.
Now, through to December 2018, you did not take any steps to review the KPIs, did you?
No.
And through to June 2019, you didn't take any steps to review the KPIs?
Well, I believe I did take steps to, as I said, I included engagement with the Office of Auditor General. We weren't able to complete that work.
Through to June 2019, you didn't take any steps to review the KPIs, did you?
Well, I believe I did.
What was the delay caused by between August and December 2018?
Staff resources and time.
Department resources?
Yes.
And not prioritising this above other things that the department was doing, would you agree?
You have to risk assess across a very, very broad range of outcomes in the agency, and we didn't prioritise this over others that we had to prioritise because of the priorities that were indicated through the audit process of Auditor General. So they gave us an idea of where we needed to prioritise.
Now, you and the other GWC members were informed in October 2019 that the Office of the Auditor General had recommended that the KPIs for GWC should be reviewed to better reflect the desired performance of the GWC for the forthcoming year?
Yes.
October 2019. You recall that?
Yes.
And if we go to this document, and not on the public screen, please, gwc.0002.0016.0289. These are agenda papers for the GWC October 2019 meeting. And if we go to page 193, we'll You'll see there a letter from the Office of the Auditor General dated the 5th of September 2019. And there's an auditor's report at 0197. And at 0199. In the middle of the page, do you see there, we're in the middle of the Auditor General's report there. There's a report on the key performance indicators. And you see in the second paragraph under opinion, there's a positive opinion expressed about the KPIs for the GWC. You see that?
Yes.
Notwithstanding that, if we go to the attachment at 0195, you'll see a moderate rating for the KPI targets, meaning that there was a finding of sufficient concern to warrant action being taken by the entity as soon as practicable. See
Yes.
that? So that gives you an idea of priority, doesn't it?
Yes, it does.
Yes. And then if we go to 0196, you'll see there's a finding about 2 of the KPIs. A recommendation that they be reviewed to better reflect the desired performance of the Commission for the forthcoming year. Do you recall that?
Yes.
Yeah. Now, you see the management comment on that page.
Yes.
Management agrees to review the target. Were you part of the management that agreed to review that target
Indeed, yes.
in your capacity as Director General of the department,
Yes.
not as Chair of the GWC?
Well, obviously, as Chair of GWC, I was anxious to meet the review of the KPIs, but it was also my responsibility as the department to do so because I reported to Parliament on performance of the agency.
Well, you accept that you were designated as the responsible person in this attachment.
Yes.
And so did you understand your responsibility here to be the primary responsibility to review at least the 2 KPIs that are referred to in this attachment?
Yeah, when practical to do so.
Well, no, as soon as practicable.
Well, as soon as practical.
Is that
to
what
do
you
so.
understood?
Yes.
Yes. And did you see it as your responsibility to review not just those 2 KPIs, but all of them as soon as practicable?
Yes.
And thereafter, after receiving this report from the Office of the Auditor General, you appreciated that the other GWC members were looking to the department to update the GWC's KPIs?
Yes.
Generally, not just in relation to the 2 the Auditor General had mentioned?
Indeed.
Yes. And when that had not happened by the December 2019 meeting, the members expressed concern. Do you recall that?
Indeed, yes.
And it was agreed at that meeting, wasn't it, that the review of the KPIs would be undertaken as a priority in 2020 by an external agency if necessary?
Yes,
And you agreed to that?
I did.
And was the reference to having to go to an external agency if necessary because of a lack of resources within the department?
If I'm able to give a slightly more comprehensive response, the Office of Auditor General, when we did an amalgamation of the departments, we had to amalgamate all our critical systems, finance systems, HR systems, payroll systems. That not only had to be amalgamated into a single system, but we had to migrate to the cloud because the building that we were occupying, which had a central server system, that system was turned off, was being turned off due to the GovNext changes, and so we had no alternative but to go to cloud. Integrating those all simultaneously and moving to the cloud posed a large number of risks that the Office of Auditor General was concerned about around data integrity and around the potential for, attack by cyber interests and so on. It was a very, very complex and technical matter, and that was of extreme risk. And of course, gaming in data, liquor data, a lot of this was all data that would be subject to this transition. My critical concern as both chair of the GWC and as Director General was to ensure that there were no breaches to the securities of all this system going on. So
I ask you to just pause there, Mr. Ord.
Yes.
I am asking you a question about whether the reference to going to an external agency to review the KPIs was because of a lack of resources within the department at that time. What is the answer to that question?
well, the answer is that the resources were allocated to greater priorities, not necessarily that there was a lack of them. It was that they were doing critical work, including work to support the integrity of the GWC.
At this time, had you looked into when the KPIs for the GWC had last been updated?
No, I was aware that they hadn't been updated for some time.
Well, since 1992? Does that sound right?
Yes, that would probably be true.
And do you recall that in February 2020, the GWC members in meeting acknowledged that the limited resources of the department made it difficult for the department to review the KPIs at that time?
Yes. We also, of course, had COVID, which was in the later period, but in the earlier period, it was the amalgamation of the departments, which limited our ability to immediately do a review of those KPIs.
All right, so at February 2020, it was a little too early, wasn't it, to see the effects of the pandemic on the resourcing and resources available within
That's
the
right.
department?
We were dealing with this other matter I was referring to, which was around the amalgamation of what had previously been 6 other bits of government.
Amalgamation of systems.
Yes.
Yes. And it was also in February 2020, wasn't it, that the GWC members agreed that in order to review the KPIs, it was actually imperative to do a risk management framework review. Do you recall that?
Yes, that's true.
And you agreed with that?
I did.
And was it at this time that the department had engaged Risk West to develop a risk management framework?
Yes.
And that was for the department as a whole, not just GWC, was it?
Risk West were doing a range of work for the department. They tend to do a lot of the government agency business. We had a number of bits of our business that required a reassessment of risk, partly due to amalgamation and partly just because of emerging risk issues.
Was Risk West preparing a risk management framework for the department?
Yes.
Was it also, at this point, that's February 2020, preparing a risk management framework for GWC?
They were preparing to do so, yes, by having workshops and such with staff.
Now, it was in April 2020, wasn't it, that there was a meeting of GWC members with the Office of Auditor General?
Yes.
And was that in relation to GWC's KPIs as a whole, or just the two that the Auditor General had previously expressed concern about?
It was primarily about the two, although I thought it would be useful for the Auditor General team to talk about their approach to KPIs. It was different. A lot of small agencies were previously audited by contractors to Office of Auditor General, and I had noticed that OAG, as we've become a much bigger agency, had a different view around how KPIs should be structured. And Treasury's view, of course, is that at a big agency, the KPIs are strategic, and had a view themselves around the nature of those. So KPIs that might have been considered KPIs at a sub-department level, once aggregated up, weren't considered appropriate. So there was a whole range of KPIs I had that Auditor General suggested should be reviewed, including these. So that conversation about how do you measure the effectiveness of the GWC was one that I was very keen for OAG and our commissioners to engage in.
So in terms of the review of the KPIs after this meeting with the OAG in April 2020, was it the case that the department and GWC were continuing to wait for the risk management framework review to be completed?
That was a stepping stone. We assessed where our risks lay. Having only two KPIs...
My question was, were you still waiting for the risk management review to be completed?
Yes.
Yes. And that was something that in GWC's mind and in your mind as chair had to happen first before the KPIs could be reviewed?
Logically, I believe so, yes.
And a year later, April 2021, was it the case the risk management framework had still not been reviewed for the GWC? It hadn't been completed?
Yes, and I did in my witness statement explain what happened when COVID hit and what was suspended in terms of work programs in order for the department to be reallocated.
Well, let's go to that. DLG.0001.008.001 at page 0005, numbered paragraph 8. This is what you're referring to here, isn't it? Is that right?
Yep.
Yes. Now, you say here in the first sentence, the net effect of COVID-19 on the GWC was the suspension of processes, including the review of KPIs for the GWC. Do you mean there suspension or do you mean delay?
Oh, it's more of a delay. We were obviously a range of gaming activities were actually suspended during the first COVID period, including closure of Crown.
But I'm asking you about the processes you've referred to here. I'm not asking you about activities down at the casino. And the simple question was, do you mean suspension or do you mean delay? And you answered delay.
Yes, so
that's
they
your
were
evidence.
Delayed, yes.
Thank you. Now, linking this then to the Risk West review, which was being undertaken by an external body, is it the case that the lack of resources attributable to the pandemic meant that department staff couldn't instruct Risk West so that Risk West could then get on and complete the framework?
Yes, the work that Risk West tends to do is workshop based with teams of people and so on. That wasn't practical at that moment of time, so we weren't able to instruct Risk West to complete that work, and they did complete some other work that they had sufficient advancement of to do, which was around liquor.
Now, it was the case, wasn't it, that the department didn't grind to a halt completely in terms of its normal functions during the pandemic?
No, I'm very proud of my staff for the fact that they stayed at their desks and continued to operate a lot of the services of the department.
So, in relation to a lot of the services that the department does ordinarily, there was a prioritisation, wasn't there, about which would continue to be attended to in priority and which would give way to resources that needed to be applied to pandemic-related activities. Is that
Indeed.
right? And who made those decisions about which conventional or usual activities were to be prioritised above others?
Well, there were a range of mechanisms for that. There was primarily a Director General's group in which we met to discuss what were critical issues. In my domain, of major concern to the government was around liquor, and we imposed for the first time ever in the statewide liquor restrictions. So our regulatory division, racing, gaming and liquor, is obviously liquor is within that division. Was heavily focused on addressing issues with the liquor industry itself and also issues around the concern that I think it was expressed that they didn't want to run on liquor stores like there was on toilet paper. And
So
we
you
did a lot of
recall
work
that
in
my
that area.
question, I'm sorry to interrupt Mr Ord, but my question was about the normal activities of the department, not pandemic related activities. And the normal activities of the department were prioritised, weren't they? Those that would continue to be given attention.
Well, we continue to employ people, to pay staff, to, exercise grant programs and the like, yes. And we continue to monitor gaming, of course, yes.
Yes. So some activities were prioritised above others, the normal day-to-day activities of the department and its responsibilities, as to which would continue.
Yes, and I had to make
Sorry,
those.
I'll just finish my question. Would continue to be supported, and those which would be subordinated to pandemic-related activities.
Yes,
And the KPIs and the risk management framework review were subordinated to pandemic-related activities. Is
Yes.
that right? And who made the decision that those KPI and risk management framework activities would be subordinated?
I would imagine it was Mr Connolly as Deputy Director General Regulation. Specifically, I don't recall making a direction to say, please stop that work. But I was aware that we were reprioritising to do the matters that I referred to around liquor.
Were the GWC members consulted before any decision was made by Mr Connolly or anybody else about how to prioritise the activities of the department during the pandemic?
I don't believe so. We obviously informed them of what was happening in relation to the pandemic and obviously what we were doing to assure integrity of the information we had to control in relation to Crown opening and closing and those matters. I don't recall that we specifically said we can't complete the risk assessment or that we're going to have to delay the KPIs so that could come out in discussions as we went on in future meetings where they asked where those matters were up to.
GWC members should have been informed if other activities of the department had been prioritised above these, shouldn't they?
In a perfect world, absolutely.
Can you explain why that appears it did not happen?
Well, it's probably due to the fact that I didn't do it.
Now, if we look back on the questions I've asked you, Ms Fiorentino raises concerns about the suitability of the KPIs back in August 2018. Now through to, was it May 2021 that you left the department?
Yeah, left the role, yes.
Yes, and left the role of chair.
Yes.
In that time, the KPIs had not been substantively reviewed, had they?
No.
Would you accept that you did not do enough during your time as chair to ensure that the KPIs for the GWC were relevant and appropriate?
Related to that matter, yes.
Would you accept that you did not do enough during your time as chair of the GWC to ensure that it had an adequate risk management framework?
No, because I considered it had a good risk management framework in the way in which it governs gaming and other matters related to its legislative responsibilities.
What was that?
Well, it's in the framework of all the policies and procedures that we had in the agency.
You had reviewed all of those and formed the view that they comprised and constituted an adequate risk management framework. Is that your evidence?
Yes.
Now, I want to change topics and talk about junkets. The briefing document you received when you commenced as Director General of the Department in July 2017 and as Chair of GWC does not provide any information or advice about junkets to the Perth Casino. Did you have an appreciation when you commenced in the role that there was a risk of criminal infiltration of junkets coming to Perth Casino?
Look, I wasn't familiar with casinos. It was not an area of interest to me personally, so I was unaware of what junkets were until they came up in discussion at the meetings. So, in terms of my overall understanding, though, of the risks of casinos, I'm well read, and obviously I read incoming government briefings and all that before I took over the department because there had been elections before. and in that it gave a general overview of gaming operations. Junkets weren't specifically part of the framework of that. It didn't refer to the fact there had been changes to regulations and so on.
So just coming back to my question, the risk of criminal infiltration of junkets coming to Perth Casino, when did you become aware of that risk?
Became aware of that really through the media reporting.
When did you become aware of that
Well,
risk?
that would have been when the first reporting around 2016, 2017, so around the time I took up the role, there was media reporting around what happened in China with Crown, and I've obviously, read that and listened to the reporting and understood the nature of where that concern came from.
So the question I asked you a moment ago was, did you have an appreciation when you commenced in the role that there was a risk of criminal infiltration of junkets coming to Perth Casino?
I didn't understand what a junket was, but I did understand that there could be concerns around people trying to launder money at a casino.
Right. When you commenced as DG of the department and chair of the GWC, did you understand whether and how, if so how, the GWC regulated junkets that came to Perth Casino?
Well, I understood from our first, when we had conversations, and Mr Connolly and Mr Sargent were able to give us an understanding that we had formally regulated junkets, but that had ceased some years earlier owing to the introduction of federal legislation, which they understood would provide the same level of assurance that those who were coming into Australia on what essentially were, resort-oriented activities with gambling involved, that they would be cleared through foreign affairs processes and financially through financial transaction assessment, banking assessment around risk and so on.
So when did you learn about that?
I couldn't recall an exact date, but I would imagine that it would have been within the first 3 months of me taking over, somewhere around there.
So did you understand in effect and in substance when you learnt about the extent of the regulation that at that time the department and GWC did not conduct any probity checks of junket operators or junket participants?
It was my understanding that probity was done elsewhere and that the GWC could rely on that probity.
So just to answer my question, did you understand that the GWC and the department did not conduct any probity checks of junket operators or junket participants?
Yes, as it was explained to me.
And as I think you've just said, that the reason for that was because there was an assumption that by the department and by GWC that Border Force effectively undertook that task of conducting probity checks.
Yes, and there had been a Productivity Commission inquiry ahead of the decision by the GWC to remove those regulations, in which they said that they were duplicating other processes. So they were acting on other, advice from other reviews as to whether that was what the Department Gaming Wagering Commission had previously done was effective and warranted. I mean, I have a different view now as to whether that was a good piece of advice or not, but at the time that appeared to be the basis for which the Gaming Wagering Commission considered lifting the regulations at that period.
So let's stay with the period where you have just commenced as Chair of GWC and Director General of the Department. And aside from the issue of probity checks, probity vetting of junket operators and junket participants, did you understand that the department did not oversee Perth Casino's junket operations to satisfy itself that the risks of money laundering were adequately mitigated?
Well, I understood that Crown had a requirement under the federal legislation to maintain a strong anti-money laundering program themselves, and that we were auditing the framework around which their licence, they held a licence in Western Australia. It was my belief that Crown, who were highly compliant on all matters we were auditing, would be applying the same due diligence to that work, and that they wouldn't put their licence at risk by deliberately seeking to breach what were very significant pieces of federal legislation clearly aimed at ensuring there wasn't money laundering for a whole range of good reasons.
So do I understand your evidence to be this, that you understood that Crown was subject to federal legislation in relation to money laundering?
Yes.
And you assumed that Crown complied with that legislation?
I had good reason to believe they did, yes.
Did you understand that the casino manual imposed any requirements to comply with that legislation upon Crown?
Yes. And
you assumed that Crown complied with the casino manual?
Yes.
Separately from that, you understood that GWC did not oversee directly any mitigation of the money laundering risk at Crown Perth?
That's as I understood it, beyond the fact that we were doing the audit programs, or a comprehensive audit program of Crown, and therefore broad compliance on all their legislative responsibilities. We had, regular reporting that was of a high order. So yes, I believe that they were complying with their legislative responsibilities.
Now, you mentioned a little while ago that when you commenced in this role, DG of the department, chair of the GWC, you were aware of media interest in people coming to Perth Casino from abroad and engaging in money laundering activities. You recall?
Well, I have to say I was aware of the concern around people coming in from China, and where Crown's activities in China were being questioned. I didn't associate that necessarily with money laundering. I said I had a view myself that there was always a risk of a casino. That's just what you would kind of think about, and a general member of the community would probably answer the same way. My understanding of the stories was the Crown had been recruiting people to gamble in China against Chinese law. And I was interested in that story and what that, actually represented.
Now, when you began in the role, were you told or did you become aware that the casino manual had only very recently been amended, i.e. within the last couple of months before your arrival, to remove the requirement for junket operators to be approved and to remove the requirement for the names and passport numbers of junket participants to be provided to GWC?
No, I wasn't aware of that.
I want to show you this document, GWC.0004.0019.0012. Is this okay? Have you seen this document before?
Well, I've reviewed it on the weekend. It was one that I did receive, and I didn't recall, and I don't recall having seen it prior to the weekend. I did note it was dated 14th of July, just after I started. Given the nature of it, I would have expected it to be on an agenda of the Gaming Wagering Commission at its August meeting.
I just asked you whether you had seen it.
So no, I don't recall seeing it, but I'd have to look at the agenda papers to see whether in fact it came up. I don't recall it, but if it was in an agenda paper, I don't want to mislead the Commission.
So I can help you with that, Mr. Ord. There's no evidence that we've seen of this being provided through agenda papers to the GWC members. But there's evidence to suggest that Mr. Connolly received this document by email from AUSTRAC on the 17th of July 2017. Now, you don't recall Mr. Connolly showing you this document at around that time?
No, I mean, it was very early days.
The question is simply Do you recall whether Mr Connolly showed you this document in
No,
around
I don't.
mid-2017? Do you recall him showing you any time after that?
No.
If we go to page 0004, and we're looking at a section here that talks about state-based regulation. Can you see if I describe it as the second full paragraph under the first two dot points, it's just a sentence that says,
Yes.
AUSTRAC found there is inconsistency between the states and territories in relation to the extent of junket oversight they undertake. And if I could ask for the table underneath that to be popped out, please. You'll see there, Mr Ord, that the WA regulator, that is GWC, has the least regulatory oversight of junkets in the sense that it has only one of the 5 oversight activities that it undertakes, which is review of casino procedures. See that?
Yes.
Did you become aware at any time during your time as DG of the department or chair of the GWC of the degree of regulation of junkets by GWC compared to other casino regulators in Australia?
No, I believe that we were consistent with other states. I did become aware through the Bergen inquiry report when I read it around Queensland having a much stricter overview, but otherwise I believe we were all operating on a consistent approach.
Now, if we go to page 0006, please. Section 4.4, over-reliance on the due diligence undertaken by DIBP, which is a reference to Border Force, Mr Ord. Do you see the second sentence in this paragraph? Several of the entities engaged by AUSTRAC for this campaign, both casinos and regulators, indicated that they place heavy reliance on the probity undertaken by Border Force when granting junket participants their visas. See that?
Yes.
Well, that was GWC's position at the time, wasn't it?
Yes.
And that remained your view throughout your time as chair of the GWC?
That was my understanding, yes.
Right. And if we go over to the next page, 0007, that first paragraph, you'll see in the second sentence, Border Force advises that when junket participants are coming in on tourist visas, unless they self-declare a criminal history or Border Force has holdings on them, they don't normally seek a police clearance certificate. It goes on in the second paragraph to be very clear that given the high risk of money laundering associated with junket activities, wholly relying on the tourist visa processing practice is unlikely to be sufficient to effectively identify high-risk junket participants. And AUSTRAC considers the heavy reliance on due diligence undertaken by Border Force to be misplaced and to constitute a money laundering, terrorism financing vulnerability. Now, did anyone within the department inform you of AUSTRAC's concerns as set out in these paragraphs at any time during your tenure as chair of GWC or director of the department?
No.
Does it come as a surprise to you to read that?
Yes. I'm also surprised that AUSTRAC didn't formally write to me as chair and follow up on it. If they had such concerns, then I would have thought that the responsible thing to do would be to continue to advocate until such time as you got a response. So undoubtedly, if this had been delivered to me directly and with that level of qualification around their concern, then I would have acted.
So your evidence is if you had been given this, you would have done something about it.
Yes, I think even allowing for the benefit of hindsight and our belief at the time, if we go back to 17, Chinese activities had ceased, but there was still high roller gamblers coming into Australia, then given they'd raised the money laundering vulnerability, that would be a clear higher order risk for the Gaming Wagering Commission. And my knowledge of all the members and their concerns over time, they would have insisted on action.
So you weren't shown this report in July 2017. You were aware, though, weren't you, that Mr Connolly travelled to Melbourne in late September 2017 to participate in a conference organised by AUSTRAC to consider regulatory issues surrounding junkets?
Yes, so we had a discussion. We were in a, as you know, at that period of time, the state was in some financial trouble, and I was under direction to avoid travel at all costs, of the whole department. However, in discussion with Mick as the director, as my Deputy Director General Regulation, he raised the importance of this conference, and I agreed that he should actually be there, should attend it, and report back to the Gaming Wagering Commission on matters that arose. So by that stage, we were obviously aware of media around the Crown issue, around China and so on, and so he went and represented us, or represented me.
So what did he tell you was the purpose or objective of the conference?
He said that there were regular meetings of gaming regulators, and he was Chief Casino Officer, to discuss risks, and that they got together and, worked out at a state-by-state level what was going on in each jurisdiction, and that he always took the opportunity to reach out to meet with us when he could. So it was a regular event. I know Mr Sargent attended some of these events himself, including international forums.
I wasn't asking you about a regular regulators conference. I was asking you about a conference organised by AUSTRAC. Do you recall that?
Look, I probably wouldn't have understood the difference. He approached me on the basis that this was a conference where the other states were getting together to discuss risks, and I agreed that he should participate.
So you don't recall him telling you anything specifically about a discussion in respect of junkets or junket regulation?
He probably would have come back, I imagine. We met every couple of weeks. So let's stay
first with what he was telling you about the reason for the conference before he went. That's what I'm asking you about at the moment.
Well, I can only recall that he asked me if he could attend this conference, or the conference there and actually asked me whether I wanted to attend the conference, and I said I wasn't sufficiently across all the subject matter to attend, but I supported him attending.
But he didn't say anything about a particular focus of the conference being junket regulation?
Well, not that I recall.
All right. Then we get to when he comes back. What did he tell you, and I presume the other GWC members, about the outcomes of that conference?
I don't recall specifically the briefings. He generally would update the GWC when we met on his attendance at any meetings, as did members, because members of the Commission went to a range of gaming meetings as well. They were fairly general in nature, but there was nothing that I recall specific to this paper or AUSTRAC's briefing on it.
I want to show you this document, which should not be put on the public screen, please. GWC.0004.0019.0023. This is an email, if we go down to the bottom of the page, an email that Mr Connolly sent to AUSTRAC dated the 29th of September 2017. That is after he went to the conference. And you read this over the weekend?
Yes.
Now, did Mr Connolly share the contents of this email with you at the time?
I don't believe so.
Right. Now, do you see the third sentence on this page where he says the Gaming and Wagering Commission does see junkets as an area that requires close monitoring?
Yes.
Was that something of which you were aware at the time?
There had always been discussion by the GWC about this, the effectiveness of this federal oversight of junkets. And I think in terms of Mr Connolly's views around monitoring, it was that we were very alive to having representation from the federal government around anything that they might wish for us to do in relation to Crown. I think it goes on around the creation of an MOU to give effect to an exchange of information.
Just stay with me with the third sentence for a moment. I'm asking you about this statement that GWC does see junkets as an area that requires close monitoring. Do you regard that as a correct statement as at 29 September 2017?
Well, in the context that I placed it in, yes.
And that all members, as far as you were aware, took the position at the time that junkets were an area that required close monitoring?
Look, I would imagine so. It's very hard to speak on behalf of individuals who were on the committee at the time. Some had different areas of interest than junkets, but I think the broad idea that people were coming in to gamble significant sums would always be a matter of concern for those on the commission.
Just coming back to this sentence, GWC sees junkets as an area that requires close monitoring. Was the assumption at this time that the close monitoring was being conducted by Border Force and AUSTRAC?
Yes, that would be my view, yep.
Because there was no monitoring, as far as you were aware, going on by GWC?
That's right, that they were in belief that it was being monitored by federal agencies.
But it goes on to say we're in the process of undertaking a full review of compliance activities at Crown Perth. You
Yes.
see that? You were aware of that at the time?
Yes.
And so was one aspect of that full review of compliance activities to see whether or not, in fact, GWC should be assuming a monitoring role in relation to junket activity?
Potentially as a consequence of the compliance audit. It was agreed that it had been some time since there had been a full compliance review and that it would timely to do one. And I would imagine at the end of that, if there were vulnerabilities to our oversight, then that would have led to us seeking to do something about that.
Did you have any sense at this time that junkets were a compliance activity that was to be reviewed?
Well, compliance with the whole framework was what I understood was going to be reviewed.
Just answer my question. Did you have any sense that junkets were a compliance activity that was to be reviewed?
Not in terms of an approval process, no.
And as you say, if we go over the page, you read over the weekend that the email goes on to say that GWC is interested in exploring an MOU to exchange key information. If we go over the page, please. Did Mr Connolly discuss with you the possibility of an MOU with AUSTRAC in advance of writing this email?
Not in advance of writing the email, to my knowledge, but subsequently he discussed that he had had discussions with AUSTRAC and other state jurisdictions, and I think they were trying to get together to come up with a standard MOU.
And when was that?
Well, I recall those conversations more in the 2019 era rather than at this date.
And did he inform you about any progress he did or did not make in discussing and negotiating an MOU with AUSTRAC?
Yes. I was somewhat frustrated that it seemed to take a long time to get what one could imagine to be a relatively simple agreement, but I think AUSTRAC's concern was around provisions in their act around confidentiality, and any MOU had to allow for respective restrictions that states might have around sharing information in their legislation and so on. So what on prima facie you would imagine could be a short process seem to take a protracted period of time.
And I come back to the full review of client compliance activities. If we go to this document, which I ask not be put on the public screen, please, GWC.002.0016.0225, which is the August 2017 agenda paper for the GWC meeting. And if we go to page 0013, please. This is a paper by Mr. Connolly to the GWC members in respect of a compliance review. The purpose is articulated over the page at 0014. Up the top there, to ensure that regulatory process and practice employed by the department is effective in monitoring, promoting and measuring compliance within regulated industries. And the third paragraph on this page, do you see where it says the review will examine existing processes and make a range of recommendations for changes to improve effectiveness and efficiency of operations?
Yes.
And that includes defining key performance and other indicators.
Yes.
And it goes on to say to ensure that regulatory effort is concentrated on areas of greatest regulatory risk, that is the risk of non-compliance. Now, reading all of that at the time, there's nothing in that you disagreed with?
No.
That I've just read out to you?
No.
And you understood that the review was fundamentally important for all of GWC's regulatory activities, not just casino regulation?
Yes.
And if we go to page 0015, under the heading of timing, it's anticipated the review will take 6 to 8 months with monthly updates.
Yes.
And was the compliance review and the way in which it was to be rolled out, as explained in this memorandum, something that Mr. Connolly discussed with you beforehand?
Yes, that he was suggesting we do it post the machinery of government. His view was that it was timely to recalibrate and ensure that we were focusing on the greatest areas of risk.
And did he seek your approval to proceed with this compliance review before he prepared this paper?
Yes.
And did you then oversee, in your capacity as DG of the department, Mr. Connolly's work on the compliance review?
He regularly reported progress on it in our regular catch-up meetings.
And you recall that the first report, the first monthly update, was produced into the September 2017 meeting in respect of casino revenue and tax verification procedures?
I believe so.
Did you discuss with Mr. Connolly the order in which different compliance activities would be addressed in the review?
No, I mean, this was early days and he was the expert that I was relying on to give advice to me on the priorities, and I took that advice.
And in October of 2017, you recall he provided the next monthly update, which was a review of table games integrity?
I believe so, yes.
And then in November 2017, there was the monthly update was in respect of security and surveillance.
I believe so.
And then in December 2017, the monthly update was the integrity of EGM gaming.
Yes.
And at that point, GWC members expressed concern in the meeting, didn't they, about the quality and content of the material coming out in these monthly updates and whether the compliance review was achieving its desired outcome?
Yeah, they asked for more details rather than just summaries of the work being done.
Were you one of the members who had concerns about the material and where the compliance review was headed?
Look, I was of the view that Gaming Wagering Commission members should receive as much information as they required to make decisions. And therefore, of course, if they didn't believe that papers were comprehensive enough, then I always supported us rewriting or supplementing those papers.
You were a member of the GWC. Did you think the papers were adequate?
Well, I had the benefit of more direct briefings, and GWC members were receiving a paper which they'd review and then discuss. So I was a more informed member, and I was of the view that the work that Mr. Connolly was doing was, was sound and was suitable for fit for purpose. But I accepted that the papers weren't adequately comprehensive enough for the other members.
Did you speak to Mr. Connolly about that?
Well, Mr. Connolly, of course, attended those meetings, and they were always frank and open discussions, and he always was very, he always took on board comments, whether they were negative of his work or not, and was happy to comply with getting the work done.
Did you speak to Mr. Connolly about that?
I didn't chastise him for the quality of the paper, no.
Did you speak to Mr. Connolly about that?
I don't recall doing so, no. Beyond the minuting of the meeting, of course, the actions.
Now, I think because there wasn't a meeting in the January of 2018, we get to February 2018, and then another monthly update on community gaming was due to be provided, and the agenda item was withdrawn. Why was that?
I think it was work pressures. The work hadn't been completed.
And it would appear that the compliance review stopped at that point?
We ran into a whole range of other matters that we had to address. And
Did the compliance review stop at that point?
I don't believe it progressed beyond that point at that time.
Right, and you were about to tell me the reason why?
It was just work pressures in the department.
Well, doing other things in priority to this.
Yes.
Yeah. You accept, though, that it was vitally important to conduct the compliance review?
Yes.
And the purpose of the compliance review was vitally important to the GWC?
Yes.
To ensure that its activities and operations were effective and efficient? Yes?
Yes, excepting we had a program of works that were maintained. This was about future improvements or sought for future improvements to current processes.
Well, it was also relevant to...
And there was auditing going on and so on.
It was also very relevant to defining the KPIs, wasn't it?
Indeed, yeah.
And to ensure that regulatory effort was concentrated on the areas of greatest regulatory risk.
Yes.
So surely it was your responsibility as DG of the department and chair of the GWC to ensure that the compliance review was completed.
Where it was intended to complete the work, there were a series of delays brought about by, as I said, the pressures the department was under in a range of other areas. Particularly, we had major inquiries in liquor licensing, significant legislative reform work going on as well. And we had to, at times, prioritise those matters as there were lives at risk.
Well, an estimate of 6 to 8 months was given in August for completion of the review. Was that August 2017? And presumably you were well aware of the resources available to the department at that point, yes?
Well, I'd just taken over what was essentially previously 4 departments, and I had to learn all of those, plus deal with the realities that were hitting us at the time. And so what I had understood the capacity of RGL to undertake some of this work, and the reality when we looked at the pressure to meet a range of election commitments and particularly the outfolding issues in Pilbara and Kimberley around liquor, then we had to reprioritise some of those resources. So we didn't try to mislead the Commission in believing we could complete the work in that time frame. It became possible due to those same officers covering those areas and having to reprioritise the workloads.
So, Mr. Ord, you would understand and agree with me, wouldn't you, that when one prioritises different activities and subordinates a currently less important activity to another, there will come a point where that subordinate activity has become so delayed that it then becomes of a great priority to complete it.
Yes, and I was critically aware of that, and to try to fill in the gap, I commissioned the Ernst & Young compliance review using our audit company to try to catch up and ensure that we were compliant.
When was that?
I think I did that late 20 or mid-20, something around that, because I was concerned that we hadn't completed everything we needed to do. And
3 years down the track.
Yes.
Would you accept that as chair of the GWC you did not do enough during your tenure to ensure the progress and completion of the compliance review?
Look, in hindsight, I could have tried to prioritise that over other matters, but I'd still contend that I was of the belief that our current program of audit of the activities of Crown related to the things that we were auditing was appropriate, that the risks were being managed, and that this work to if you like, modernise and improve our oversight of risks would be accommodated and done as soon as we could do them.
Now, you recall in July 2019, 60 Minutes broadcast a story on the Crown Group,
Yes.
and you understood that the story raised issues about criminal infiltration of Crown casinos,
Yes.
in particular by junkets,
Yes.
and you knew what a junket was by July 2019.
Yes.
And I want to show you an email you sent to the Director of Corporate Communications of the department the following Monday after that 60 Minutes program was broadcast, dlg.8001.0003.5307. So we need to go further down into the email chain, please. Just scroll through. Right, we just pause here. So that's, do you say his name Damien Carbon or Carbon?
Carbon, yes.
Carbon, who was the Director of Corporate Communications from your office, is that right?
Yes.
And you'll see at the bottom of this page that he has sent through to you and a couple of other people within the department, including Mr. Connolly, links to newspaper articles.
Mm-hmm.
And you say above that, at 9:58 a.m, can see why Packer cashed in his chips. Hope our probity audit is rigorous. When you hoped that the probity audit was rigorous, you were referring to the probity audit of GWC, not the department?
GWC probity audits, yes.
And did you know what the probity audits were that were being conducted by the GWC at this point?
Broadly, yes.
And what were they?
Well, they're around, audits of gaming machines, audits of the, various accounts, taxation audits and the like.
These were newspaper articles linked to the subject matter of the 60 Minutes report, you recall that, to do with high rollers and junkets. And your response is, hope our probity audit is rigorous. You were referring to probity audits around junkets and high rollers, weren't you?
No, I was meaning in that case I meant our probity audit, should have been audits I suppose, are rigorous across the whole business. That's what I was thinking.
And in terms of probity, what are you referring to there?
Well, the allegations that were being made was that essentially Crown was facilitating people to bring in where the source of the funds could be inappropriate, and to facilitate them gambling that money in in the casino.
Money laundering is what you're referring to.
Well, that was the accusation that it potentially could be money laundering.
Well, didn't you tell me before that you understood that AUSTRAC was responsible for mitigating that risk?
Sure.
So I understood your evidence to be before that as a consequence GWC didn't oversee that risk itself.
Well, I didn't think that GWC was responsible for checking the bona fides of people coming into Australia and the sums of money they were bringing with them. I never had the belief that we weren't responsible for ensuring Crown Perth was running an appropriate business at all aspects of its business. So I was fully aware they had an anti-money laundering policy and governance around this, and my expectation was that was rigorous and protecting Crown Perth from people coming in to launder money. We're using their business to launder money.
So just in relation to money laundering, what is the probity audit of GWC that you're referring to here?
Well, as I said, it's a very quick response. I was referring to the fact that I hope that our probity audits of Crown were up to scratch.
Did you think at the time that GWC conducted probity audits in relation to Junket operators, participants and risk of money laundering?
I believe that we were covering the critical business activities of Crown, not that we were doing probity audits of people coming in as junkets or the junket operators, but we were covering off the activities once people landed and were active in the casino.
So a probity audit in relation to potential money laundering activity?
Well, certainly, yes.
You thought that that's what GWC was doing?
I thought we covered that off, yes.
Right, thank you. That's a convenient time, Commissioner.
Thank you, yes. We will adjourn until 11:30. Thank you. Good morning, team, Mr. Ord. And we'll be back at 11:30. Thank you.
All right. rise.
Thank you. Please be seated. Yes, Ms Cahill.
Thank you, Commissioner. Now, Mr Ord, I had you at that email chain of the 29th of July, just before the break, and in coming in the aftermath of that 60 Minutes program the weekend before. And you make reference to that 60 Minutes program in your third witness statement, I think it is, DLG.0001.008.001. And if we go to page 0015, here we are at paragraph 48, where you start talking about the Bergen inquiry, and you say, first of all, I'm going to tell you about the 60 Minutes story. And if we go to paragraph 49, you say, just stay on page 0015, after the story, the GWC immediately requested a formal Crown response. And that response was in terms, was it, that there was nothing to be concerned about as far as Perth Casino was concerned?
In essence, they sought to give assurance that, that these matters were, that they contested elements of the story, I guess one might say, and that Crown Perth, was not subject to accusations of a similar nature to the ones outlined in the program, which was around people bringing money into Crown Melbourne. And as I understand it, there was Sydney was included in that story.
Would you agree that the GWC accepted Crown's explanation at this time uncritically?
No, I think what our focus was at the time was whether the practices that were outlined, and they did go back, I think, in that story to 12, 6 and 16 primarily, and related to people coming in from China and so on, that we were aware that the China business had concluded in 16, and we were given assurances by Crown that the accusations were largely historic and they had taken action to correct risks that had arisen from that anyway, and that they had acted on legal advice that their activities were, in terms of the recruitment of people out of China, were within Chinese law. So we were concerned about whether there were going to be allegations against them and so on. And they gave that assurance at that time. So we believed at that stage that we had required them, and that coming before the Commission, that we wouldn't be misled on those matters, and therefore the risks that had been aired by that report were already being addressed within Crown's business. And so we took a watch and wait and see approach to see whether there was follow-up, as I indicated, from the odds track that we would get contacted by a federal agency to say, there's a problem in Perth, you need to do something about it. So I
my
was expecting that.
question, Mr Ord, was whether GWC accepted the explanation of Crown at this time uncritically. And I understood you to say a moment ago, in the middle of that very long answer, that you assumed that that Crown wouldn't mislead you in relation to the explanation it gave.
Yes.
So you accepted what it said uncritically.
Sure, it's quite the same thing, but we accepted that we were being told the truth.
You aware, are you, of the evidence given by Ms Chopping, the new Director General and Chair of the GWC, to this Commission last week, where she expressed the view that in the past the GWC and the Department had an excessive level of trust in Crown?
Yes.
Would you agree with that evidence?
I think it would be a reasonable view to take for a new DG. I'd probably do the same if we were in reverse roles.
I just asked you whether you agree with that evidence.
Well, I said yes.
And would you agree that specifically on the occasion of Crown giving its response to GWC about the content of the 60 Minutes report, you as chair of the GWC placed an excessive level of trust in Crown in accepting that response uncritically.
Yes?
Now, you go on in this paragraph 49 over the page of your witness statement to explain, in effect, that and in terms at paragraph 50, that it was reasonable for the GWC to await the outcome of investigations by AUSTRAC, Border Force, Bergen Inquiry and the VCGLR before inquiring, GWC inquired itself into the issue about junket activity at Perth Casino. Do I understand that correctly?
Yes.
In that regard, if we can come back to the email chain I showed you before the morning tea break, that's DLG.800100035307. You got this explanation from Mr. Connolly that begins at the bottom half of the first page. And just before I ask you about that email, did Mr. Connolly ever say to you or suggest to you that someone from Crown had told him about the 60 Minutes program before it was broadcast?
Not that I recall.
All right, now Mr. Connolly's giving you an explanation on the Monday morning, saying he hasn't seen the television story yet, but in terms he has a sense of the allegations. And in this second paragraph, explains that in WA we don't approve or licence junket operators. Did you already know that?
I believe that same kind of explanation had been made at a Gaming Wagering Commission prior to me receiving this email.
So did you already know that fact in the first sentence?
That we didn't licence them.
Approve or licence junket operators. You already knew that.
Yeah.
And then he goes on to say, excuse me, it's historically been extremely difficult to conduct any sort of probity assessment of individuals coming out of some other countries, particularly Indonesia and China. And then he says in the late 80s, 90s, GWC funded a police unit tasked with vetting and gathering intelligence on junket players and operators, but that was discontinued 15 or more years ago. And in terms, he goes on to say that since then we've relied on border protection agencies. Now, in the third paragraph, he says in the first sentence, we've been criticised for this approach before. Were you interested to find out by whom GWC had been criticised and why?
Look, I understood that a lot of gaming regulation in Western Australia was criticised. There is a healthy debate in the community. Many people are totally opposed to gaming. So, no, it didn't come as a surprise that we were under criticism over any activity that took place.
That's not what I asked, Mr. Ord. And we come back to the second paragraph. He's explained that there's no approval or licensing process for junket operators or participants in WA, that there used to be a police vetting exercise that was defunded 15 years or so ago, and since then GWC has been relying on border protection agencies. He says, we have been criticised for this approach before, and I expect will be criticised again. My question is, were you interested to find out by whom GWC had been criticised?
I didn't pick that up on the basis of the question as an issue that I'd pursue on that basis. I was aware that many of the resources that are applied, police units and so on, may well have been discontinued as part of decisions of government around budget. So I was very familiar with that because I was managing a major restructure to achieve budget savings at the time.
Did you want to know what the criticism was of this approach of relying on border force agencies?
I took it, and I'm sorry if I misread the paragraph, that it was about the taking away of the police unit.
So did you want to know how that had come about and why?
We did discuss it at a later date.
When?
One of our general meetings, I think he mentioned that we did have a police unit, but that had been disbanded in a savings measure.
So this reference to having been criticised for this approach suggests to you, doesn't it, that someone who was making the criticism perceived that there was something more GWC could be doing to vet the probity of junket operations coming to Perth Casino?
Yes, I'd agree, and I think I have stated in my views around the future that, you know, those matters, if they were ever returned, of course, I led the direction notice to ban junkets, but if there was ever a reintroduction, then clearly they would have to be subject to extraordinary amount of scrutiny.
Now, at this point, on the 29th of July, Mr Connolly was suggesting to you, wasn't he, that the way to respond to this 60 minutes broadcast in terms of the regulator's response, GWC's response, was to wait to see, first of all, how the Victorian and New South Wales regulators responded?
Yes, because the specific focus of the 60-minute story was actually focused around activities happening inside of Crown, and we had made immediate contact with Victorians and they indicated they were going to investigate those particular matters. Then, given there hadn't been a case study in Perth that we could investigate ourselves, so it was just mentioned that we were subject to the same, as a unity business essentially, that we would wait to see whether the Victorians were going to advise us that they had actually found breaches and wrongdoing there, and of course, the outcome of Bergen inquiry later was that they had the resources to do a really significant investigation and sought us to participate in that.
You understood that those inquiries would likely take some time to complete?
Yes, I understood, not obviously as long as they did because COVID interrupted the inquiry, so I was expecting that it was going to be concluded within the original time frame, which was relatively short.
What did you understand that to be?
I think it from memory, it kicked off in 19. I think it was due to report at the end of 19.
So within 12 months?
Yeah, less than, I think, was the original target date.
And did you understand that the inquiry by the Victorian regulator would take a similar amount of time?
No, I understood that was going to be, because it was quite specific around the cage activities, that they would conclude that work relatively quickly.
How soon?
I would have thought within 3 months.
Right. And Mr Connolly also suggested to you at this time that there be a uniform process set up across different jurisdictions to deal with junket operators and participants, didn't he?
We'd been discussing,
So can you just answer the question directly,
Yes, we
please?
did have those discussions.
Thank you. And you understood that that would take some time to get up and running if it proved capable of being done?
Yes.
Yeah. So did you turn your mind to whether any interim arrangements should be put in place by the GWC pending the completion of the interstate inquiries or setting up this cross-jurisdiction regulatory framework to mitigate the present risk of criminal infiltration or money laundering at Perth Casino?
Well, at that stage, we didn't have any evidence before us that this was actually happening in Crown.
Is that what it took for you to act, Mr Ord? You'd actually have to see criminal activity or money laundering at Perth Casino before you thought you should be moved to act to mitigate a risk?
Well, in this particular instance, we didn't have a belief that we were subject to that risk, and that there were inquiries that Crown had informed us that they were taking extreme due diligence and so we didn't seek to put any further direction notices in at that stage.
You use the language of
constrain
extreme
business.
due diligence. What do you mean by that?
Well, they were reviewing all of their policies, procedures and the activities in terms of high rollers coming into the casino to ensure that they were appropriate people and weren't laundering money. That was my understanding of their assurances.
With hindsight, do you accept that you should have put interim measures in place at July 2017 to mitigate the risk of money laundering occurring through junkets at Perth Casino?
With what I learnt, obviously, through the information that came through the Bergen inquiry, then yes.
Can I take you to a different topic now, which is harm minimisation, Mr. Ord? Can I take you back to that briefing note that you were given by Mr. Connolly when you commenced as Director General and Chair of the GWC in July 2017? That's DLG.8001.0045.9601. If we go to page 9626. Do you see 2/3 of the way down the page the title Prevalence of Problem Gambling?
Yes.
And immediately underneath that you are told that WA has a low prevalence of problem gambling.
Yes.
Now, just hold that thought and then we go to your second witness statement, DLG.0001.003.002. At page 0004, paragraph 14. Where you say problem gambling is a massive risk to the community. In your mind, are those two statements consistent?
I have a concern about problem gambling myself, which was probably inconsistent with what was in that briefing.
Did your view of the extent of problem gambling in Western Australia change over the time you were chair of GWC?
Not particularly. I had been Deputy Director General of Aboriginal Affairs and I had a great concern around problem gambling within, particularly in remote communities.
So what did you understand its prevalence was in WA when you came to the role of chair of the GWC?
That there was problem gambling in selected vulnerable populations, not necessarily related to Crown Casino or matters that we regulated, but in a broader community sense. Not all gambling is regulated.
Now, what sense did you have of the prevalence of problem gambling at the casino when you became chair?
I had the understanding that the state was more highly regulated than other jurisdictions, in particular because so much problem gambling was associated with pokie machines and their prevalence in other states where they were in hotels and clubs and various other places, and that WA had taken a precautionary view to limit the number of electronic gaming machines that could be held in the casino and not to allow others to become overly populated in the broader community or agree to EGMs being held elsewhere.
So you've used two different expressions there, poker machines and EGMs.
Yes.
Is there a difference between the two in your mind?
Well, there are defined differences under our regulations. When Burswood was originally approved as a casino, there was an agreement that they could have electronic gaming machines as long as those gaming machines didn't replicate what a poker machine was, as understood by a poker machine, which is a spinning reel machine. So
sorry, can you just come back to my question?
Yes.
Is there a...
He's answering with respect what he understands the difference to be.
I'll ask your question again.
Thank you.
Let's...
I'm asking you if there is a difference in your mind between poker machines and EGMs.
Yes.
Thank you. Now, is there anything you want to add to that answer?
Yes, please. So, poker machines derived from a mechanical device which used to spin reels, and were known as fruit machines or slot machines, these sort of things. Most people understand what they look like. 3 lemons come up with something or other. Electronic gaming machine is an interactive entity. It wasn't allowed to have spinning reels. It had to have a defined return to player, 90% return to player of the distribution of money invested in the machine. And those differences between an EGM and a poker machine were enshrined in regulations. The difference is that poker machines have become electronic and have now migrated towards electronic gaming machines. So the distinction between the two currently is quite slight.
Now, you recall in December 2017, Crown Perth briefed GWC members on the Responsible Service of Gaming, or RSG, initiatives at Perth Casino.
Yes.
And if we go to the February 2018 agenda papers, GWC.000.0016.0251, at page 0004, we're in the minutes there of the December 2017 meeting. If you have a look at paragraph 5.3, it's referring there to the presentation that was given.
Yes.
And then in the second paragraph, following the presentation, members agreed to request ongoing statistical information from Crown Perth in relation to the number of third-party referrals from Crown employees and the outcomes of these referrals. What was the purpose for which that statistical information was collected?
The GWC committee were particularly interested in controls related to responsible gaming. That's particularly around people who seek to self-nominate to be unable to go and gamble. For people who, through court or other orders, are not allowed to be on premises and so on, and the degree to which Crown monitored that and recorded people who were turned away from the business, if you like, because they were not approved to be on the premises, people who were removed and people who were subject to interventions from responsible gaming officers. So they were the statistics that hadn't previously been provided that the Commission wanted to start monitoring so they could see the effect of what Crown had said were significant ramping up of their efforts to improve their compliance. One of the major initiatives was the introduction of facial recognition, so they were better able to identify people and not relying on officers on the door to recognise someone that had a banning notice. So we were interested to see the effect of these and to ensure that there was continuous improvement in the program.
Right, now, so you wanted to see the effect of changes that were introduced and whether you could see continuous improvement. Did the GWC obtain any assistance in analysing or interpreting the statistical information it was receiving?
No, it was being audited as a program so we could see it was happening, and the commissioners were reviewing the outcomes of that. Of course, there was, through our contribution to national research into problem gambling, there was information coming forward and there was national statistics. So we often use proxies to see, the gambling rate per head and these sort of things to see where there appears to be an emerging problem with either, a much greater take of gaming revenue per head or participant, so on.
What do you
so
mean
it was a
using
combination
proxies?
of information.
What do you mean using proxies?
Well, the data that were on spend per head on gambling, for instance, at a state level, there were variations around the state. We would have a look at those to see whether Western Australia was showing any increase from its traditional baseline.
Can I just pause? I'm asking you about the second paragraph of 5.3, which relates to third-party referrals from Crown employees and the outcome of those referrals. So that's a specific subject matter, isn't it?
Yes, that's true.
Yeah. And it relates to the prevalence of gambling-related behaviour evidencing that a gambler or their friends or family were at risk of harm to the extent that someone refers them to a RSG service.
Yes.
Whether it's an exclusion order or counselling or something like that.
Yeah, from the program we're running, yeah.
And is your evidence that GWC wanted to know about that information particularly in order to understand what improvements were being made by Crown and whether they were having an effect?
Yes.
And so the statistical information that was being given in that regard, GWC didn't get any assistance from any experts to analyse or interpret that information?
No.
And did it undertake any research or have anyone undertake research on its behalf to assist in analysing or interpreting that statistical information?
No, it was shared with the Problem Gaming Committee and Department of Communities and others. If we were undertaking a formal review of problem gambling, it would involve multiple state agencies and their research and data capabilities.
So was that mainly what GWC did with it, shared the information?
And obviously we considered this information when we were making approval decisions. We always made approval decisions really based on three tenets: whether it was compliant with the Act, what the potential impact of that approval on harm minimisation, and did it go towards the appropriate development of the business, which is other requirements of our consideration, so a balance of interests model.
Can I come back to 5.3, the third paragraph? Members discussed availability of studies regarding the impact gaming machine and game design may have on gambling addiction. First of all, were you aware during your time as chair of GWC of the fact and amount of academic research available on the topics of gambling behaviour and harm minimisation generally?
Yes, I was aware that there was national research on these subjects.
And in relation to EGM specifically?
No.
You weren't aware that there was of the extent of academic literature on EGMs and addictive behaviour?
Not specifically on the EGMs that we had regulated at Crown.
Did the GWC during your tenure, as a matter of course, keep abreast of academic research in the area of problem gambling and harm minimisation?
We would receive briefings and papers, and we had an officer in the department who was dedicated to responsible gaming. She serviced the problem gaming subcommittee, and there was work done within the subcommittee around the issue.
Who was that?
I'm sorry, she didn't report to me. She reported through to the Deputy Director General, so Mr. Conley would be able to give you advice on that, officer.
Looking at you as chair of GWC at the time, and the GWC membership, not the subcommittee, but the actual GWC as a group of members, did the GWC, as a matter of course, keep abreast of academic research in the area of problem gambling and harm minimisation?
There were a number of members who were particularly focused on this issue from when I first began, and they brought forward matters that came from them reading research. So it was an active debate continuously in the commission. We didn't have a kind of research program, if you like, that would have informed members if they had been full-time commissioners, for instance. And obviously ours were not full-time commissioners. So no, we didn't have an active program of research in responsible gaming to the point where you would say that every commissioner was an expert on the subject matter.
Do you agree, with the benefit of hindsight, that the GWC during your tenure ought to have had a standard agenda item for every meeting dealing with harm minimisation and responsible service of gaming?
Well, I believe it was integrated into all of the processes of the committee meeting, and it was discussed in the statistics were primarily focused on that subject matter.
So you're not suggesting it did have a standing agenda item on
No,
harm
I'm saying it
minimisation?
was seen to be incorporated in the agenda.
Coming back to my question then, do you agree, with the benefit of hindsight, that there should have been a standing agenda item for each GWC meeting dealing with harm minimisation and RSG?
I think that would be a very positive initiative, yes.
Would you agree it should be the first and priority agenda item for the GWC?
Well, it comes down to, you know, the role you ultimately set for the Gaming Wagering Commission. If it's to be that its key responsibility is RSG, then it probably needs to be constituted, probably needs legislation that reflects that. And then ultimately, yes, I would concur it would be the major priority.
But absent that, your answer would be no.
Well, responsible service of anything, if it's say liquor, for instance, which we also regulated, then it's clear in legislation the responsibilities of a licensee for the responsible service of alcohol. We can audit against it and so on. If we're doing research into the harm of liquor, then we do inquiries in Section 64 inquiries, and I had those underway in my tenure, heavily involving health, police and a whole range of agencies, because, you know, it has to be evidence-based, academic institutions and the like. If the Gaming Wagering Commission is to have those powers and responsibilities to do that for all of gaming, then they would have to draw on and have the same powers to compel to get all that information. To just say, take some random research from somewhere around the world and apply to WA, I don't think that would be practical or appropriate. It would have to be drawn from a statistical and evidence-based approach in Western Australia, in which you'd need significant cooperation from a whole range of agencies. The state government has, you know, focused heavily on how to share a lot of this data. It's, you know, it's quite complex to get access to a lot of the fundamental raw data you'd need to actually do causational connections between somebody who, you know, may be going to Crown Casino occasionally and the problems they may manifest as a problem gambler and other circumstances.
So do I understand your position correctly, that you don't perceive the GWC to be presently empowered or resourced to foreground RSG and harm minimisation as a key focus and objective of the GWC's function?
Yes, that's my view. The limitation of that is that through the statutes and policies and standards that are applied, obviously they attempt to control harm by way of saying you can only have X number of machines, they can only do this, etc., etc.
Now, coming back to December 2017 and those minutes that I took you to a moment ago, where it was talking about harm minimisation in relation to EGMs, you knew, at least by December 2017, didn't you, that electronic gaming machines are of particular concern in terms of the risk of harm arising from their regular use?
Yes.
And from the commencement of your time as chair of the GWC, you were obviously aware of the prohibition of poker machines in Western Australia?
Yes.
And did you understand that the reason why poker machines were prohibited in Western Australia was because of the risk of harm arising from their regular use?
I was aware that the proliferation of poker machines elsewhere in Australia was seen as something the Western Australia didn't replicate, and there was, through my lifetime, regular political discourse on the fact that WA didn't want to go down the road of having poker machines licensed in, many venues. And clearly, when they established Burswood Casino originally, they limited the availability of machines to electronic gaming machines and not to have poker machines.
Yes, so we're just talking about poker machines here. You understood that they were prohibited in Western Australia, including at the casino.
Yes.
And did you understand that the reason why they were prohibited was because of the risk of harm arising from the regular use of a poker machine?
The proliferation in the community, and therefore, if they're everywhere, then there's more likely that people will use them.
Well, they're nowhere, though, in Western Australia, are they, according to law?
According to law, no.
Yes. And you understood that the reason why the law stipulates that they're nowhere is because of the risk of harm from the use of poker machines?
I would imagine that was the main concern, yes. There may have been many others, and it's ruined the pub culture in Melbourne.
And I understood from what you said a moment ago in relation to an earlier question of mine that you understood by the time you commenced in the role of chair of GWC or shortly thereafter that electronic gaming machines had been developed and become available in Australia subsequent to the prohibition on poker machines being introduced in Western Australia.
Look, I'm not fully aware of the full history of when EGMs were approved for Crown or for the Burton Casino. I thought that it was on commencement that they were allowed to have electronic gaming machines.
So do you remember when the poker machine prohibition came in?
Well, that was clear in the legislation when they originally proclaimed the casino. That was clear in the reading speeches that pokies were not to be there.
Now, let's go to the briefing paper that you were given by Mr Connolly when you commenced in your role. I gave you just for the transcript, identify DLG.8001.0045.9601. And if we go to page 9655, you see poker machines there being discussed at the bottom of 9654. And if we go down to the bottom of this page, do you see that paragraph that commences contemporary poker machines are sophisticated electronic machines which look very similar to other gaming machines? Can you pick that up?
Yes.
And then it goes on to talk about what poker machines now provide with some dot points, identifying that they're similar to gaming machines and therefore makes it very difficult for the ordinary person to differentiate between the two.
Yes.
And that's a position you understood at the time, and you still are of that view that it's very difficult for an ordinary person to distinguish a poker machine from an electronic gaming machine.
Yes.
And then over the page at 9656, do you see second half of the page, comparison of poker machines and gaming machines?
Yes.
It says on the first paragraph, the issue confronting the GWC nowadays is that there's a very fine line between EGMs and poker machines. And again, that accords with your understanding. Yes?
Yes.
And then you're given some some information in tabular form as to how the GWC seeks to differentiate between the two types of machines. This is as at 2017, when you commenced in the role.
Indeed. Yeah.
And you understood, didn't you, that this table was contained information not that had been imposed on GWC, but how GWC had worked out itself how to differentiate between a poker machine and an EGM.
Yes.
Because the legislation prohibiting poker machines did not itself identify or define what is and what is not a poker machine.
Yeah, that's right. So
Yeah.
the Gaming Commission created guidelines.
And you also understood that the differentiation as it's set out in this table is expressed in an appendix to the National Gaming Machine Standard.
Yes.
So just to be clear, the very fine line between poker machines and EGMs you understood to be a very fine line that GWC itself had drawn.
No, I think I took it that it had been easier to define. And as I said, with the evolution of poker machines, they were effectively becoming electronic gaming machines. The issue of definition is Australia now full of electronic gaming machines more so than Australia full of pokies? It's an emotive issue around the definition. I'd still come back to, regardless of the effect on an uninformed player, if they could pick the difference, that the prime control in Western Australia was a limitation on numbers of machines and the fact that they could only occur at Crown. And that the guidelines as agreed by Gaming Commission were implemented.
But you understood that the GWC could change its requirements for an EGM at any time, couldn't it?
Yes.
To make EGMs in Western Australia more distinct from poker machines than they were at this time and currently are.
You could. It's a question of whether that would be something that would be accepted by the consumer. Well, you're not forcing people to play these games. They choose to play them because it's entertaining, one assumes.
So if we come down to this table that you should have on the screen, do you see just a little below halfway down, there's an item return to player?
Yes.
And it differentiates a gaming machine from a poker machine in that the gaming machine RTP is 90% or higher, and for a poker machine it's 85 to 87%.
Yes.
So did you assume when reading this material and understanding that difference between the two RTPs that a 90% RTP was less harmful than an 85 to 87% RTP?
I took it that the 90% afforded the consumer a better outcome for the risk that they were taking in playing the machine.
Did it have any significance beyond that in your mind?
In terms of whether it did less harm, well, I assume it would come down to the volume of how much you're prepared to gamble. But primarily I saw it as advantaging the consumer.
Materially?
Not materially given, but I think a very important principle to establish that there is a fixed return to player for those machines, and the fact that it's a higher rate than provided for in any other state jurisdiction is a good thing.
Just means it's fairer to the player.
Fairer to the player, yes.
All right. Now we come to the speed of play, which is a couple of items underneath that. Do you see the row that talks about speed?
Yes.
And although it's got 1 to 2 seconds under poker machine, we should read that as meaning 3 to 5 seconds per play, having regard to the note in parentheses under speed.
Yes.
Yeah. So the minimum speed of play for a game on a gaming machine has to be 5 seconds, and for a poker machine 3 to 5 seconds.
Well, 3 seconds is the national standard.
All right. So let's say 3 seconds. So a difference of 2 seconds.
Yes.
Was and is your assumption that a minimum speed of play of 5 seconds is less harmful than one of 3 seconds?
I'm not an expert on these things. One would assume that the slower the game cycle, that over any period of time, there'll be less possible to gamble But that would have to take into a whole lot of, realities around the people that play this and not. So my assumption is a slower game speed.
So why does the GWC stipulate a 5-second minimum then? What's the benefit of that?
Well, I think the issue is that the part of the rule was there should be player engagement and manual, engagement of setting off the game, no autoplay functions, and the ability for player choice. So to allow for those, having a bigger cycle means that I believe that people can make a bit of an informed decision of what they're going to do next in the next cycle.
And the 2 seconds is material, is it, in that regard?
I would assume, we'd set a 5-second standard, must have been done, that was done prior to my time. And I know the Gaming Wagering Commission, in viewing these things and in viewing Crown submissions around this later on, was of the view that the 5-second minimum was the 5-second minimum they wished to maintain.
Did it have any scientific basis?
I wouldn't know. I dare say it did in times when it was set as a standard prior to my time as chair.
So you yourself can't say what the 5 seconds is based on, why it's 5 seconds and not 8 seconds or 30 seconds or 1 second.
I think that there's clearly an expectation around how a game would perform, and the 5-second minimum must have been established on, a whole matrix of issues, including, particularly, given it's a game for people to enjoy, what cycle of speed would be to keep the player engaged or for the player to get a good experience out of what they're doing.
Symbols, so that's about just above spinning reels. You see that?
Yes.
So you can have card and sort of casino-based symbols, if I put it that way, for a gaming machine, but you can't have fruit and things like that you have in a sort of other symbols that you have in a poker machine.
Yes.
What's the reason for that differentiation?
I think that poker machines were heavily identified with a set of symbols, that are long-standing, that people would recall, an orange or lemon or whatever it might be, and they didn't want that to be simply replicated in a gaming machine.
Why not?
I'm assuming it was an attempt to make the gaming machine, more of something that was, not about repetitive behaviours.
And somehow the symbols contributed to that?
You would think that was the rationale.
Do you know?
Well, the issue with spinning wheels and these repetitive, go 3 lemons, 2 lemons, 1 lemon is well identified as a poker machine type process.
But you can have that with a card symbol though, can't you?
Well, you could, yes.
Yeah.
So the differentiation is somewhat
Illusory?
illusory, yeah.
You don't know if it's based on any scientific evidence or academic study.
I'm certain that the developers of gaming machines, do have a look at how people respond to their games as they do in games available on your computers. So they've got a lot of thought put into how they operate.
Have a look at the bottom line, winning combination lines. Poker machine can have multi-line, multi-directional winning lines, but gaming machines can only have horizontal and vertical.
Yes.
What's the reason for that?
I'm not aware of the reason for that.
And you never found out during your time as chair of GWC?
I had assumed that the winning combination lines were around it, not replicating a poker machine.
But for what purpose?
Well, it's to do with where the alignment of wins comes from. So gaming machine that's an independent, often flip of a tile, and they come up in horizontal or vertical patterns.
Did you understand it to have any harm minimisation characteristic?
No, just differentiational.
Given your understanding that both EGMs and poker machines had the potential to cause harm when used regularly, during your time as chair of the GWC, did it strike you as odd that the differentiation between poker machines on the one hand and EGMs on the other was so fine?
I was aware that, as everyone would be, that gaming is an industry that's arrived. Gaming generally is an industry, a massive proportion that's arrived, and wasn't around 15 years ago or in very different form. So the uniqueness of a game in a casino versus today versus what it would have been 20 years ago is dramatically different. So undoubtedly software developers developing games for casinos were applying more gaming concepts into their machines so that they were more experiential. People were more doing things and getting engaged with them. Free plays, lots of things that replicate what you see in games that you might play at home. So my understanding from that perspective is that we were reaching a crunch point around this, around how the software program development of gaming machines were going to play out, and how that differentiation between poker machines, if they're totally evil, gaming machines, if they're not, how that differentiation would apply.
What do you mean a crunch point?
Well, a point where the software development of games, and you can't just put one game on an EGM and leave it there for 50 years. They get refreshed regularly, different types of games. That as software developers put their efforts into it, that they were getting more and more complex. The games were getting much more complex and interactive, and that was going to make it very difficult to differentiate. If they were doing the same in pokers, they would end up coming together. So the only way of resolving that would either to say then don't have any gaming machines in Crown at all.
Well, the GWC was administering the gambling legislation in Western Australia, wasn't it?
Yes.
And you understood that included a prohibition on poker machines.
Yes.
And you understood that the reason for that was, as you, I think, agreed with me before, because of the harmful risks associated with using poker machines.
Well, I didn't say that if there were the same limited number of poker machines in Crown as there are EGMs now, I couldn't tell you that they're more harmful than if they're EGMs. I don't know. You're asking me about poker machines being introduced in WA, and I'm saying you have to take that into the broader context of the fact that poker machines are quite prevalent all around the other jurisdictions, not just in a casino. So that said, yes, I understand that we weren't to have poker machines in Crown either, or anywhere else in the state. And remember, our coverage was not just the casino, it was gaming more generally. And we were, aware of the risks of proliferation of pseudo poker machines. So it was a concern, and, one that undoubtedly, and I'm very pleased the Commission's looking at this, should be brought to government's attention. And it's a political decision. If they don't like the fact that EGMs have become like pokies, then there's a simple solution to the problem.
Have EGMs in Western Australia become like poker machines, in your view?
Well, I've given testimony that they are very close, and I'm not sufficiently an expert to be able to tell you the level of differentiation that would apply that would convince you that an uninformed person would know the difference.
So I'm just asking you about your own view.
Well, I'm just a citizen and I have that view.
And you mentioned a moment ago that poker machines proliferate, that's my word, not yours, in the eastern states. Do you mean poker machines, or do you mean EGMs, or do you mean both?
Now, I understand that people are using the poker machine software because they consider it's more attractive to people who like using those kind of machines, that our machines are slow, they're
And by
doing
that
a whole
you
range of
mean
things.
machines that fulfil the criteria under the poker machine column in this table that I'm showing you.
Yes,
For example, 3-second minimum speed of play rather than 5.
yep, those kind of things.
Those kinds of things. Now, can I ask you about approving games to be played at the casino, particularly approving games to be played on EGMs, electronic gaming machines? This, during your term as chair of the GWC, was a significant part of the function and work of the GWC members in meeting, wasn't it?
Yes.
And if we come back to this briefing paper at page 9655, so that's just on the previous page, at the bottom, there's a reference there to clause 22, sub clause 2 of the state agreement. And that's recited, and then when we go over the page to 56, at the top, it says the above clause puts an onus on the Commission to approve a game if it's played in another casino in Australia or elsewhere and the rules are acceptable to the GWC. Then goes on in the next paragraph to explain that if the game's not played in another casino, the GWC has the discretion whether to whether to approve the game if the rules are acceptable and it is not considered to be a poker machine. Does that accurately set out your own approach and understanding about what decision you had to make in terms of whether to approve a game during your tenure as chair of GWC or to not approve one?
As I said, we applied those 3 foundation principles where was the request consistent with the Act, and secondly, did we believe that the request would significantly change the harm profile of the casino, and thirdly, did it meet this requirement under the Act of allowing for the responsible development of the business? So it perhaps misses out, some of the elements that we would apply to a decision where we had discretion as to whether to approve or not.
Well, let's go to that specifically. It says to you in the first sentence, the first paragraph, the above clause puts an onus on the Commission to approve a game if it's played in another casino in Australia or elsewhere. So if it's played outside of Perth casino, in a casino, and the rules are acceptable to the Commission.
Yes.
So if the rules were acceptable and it was played in another casino outside Perth, did you understand that the Commission had a discretion to not approve the game, or was it obliged to approve the game?
Well, given if the rules are acceptable to the Commission, there was clearly an opportunity to say those rules aren't acceptable and there'd be a reason for it. Where this would apply, and it did apply a number of times during my tenure as chair, was where they asked for some changes to for roulette, introducing a 00 in roulette. I think they asked for some changes to poker. And the argument was that this is done elsewhere in Australia. Players are familiar when they come to Crown Perth, and some of those functions were not there, or whatever, that changed the player engagement and experience. And so they might ask for an amendment to the game or rules as we had certified them, to allow for commonality between jurisdictions.
So I'll come to variations in approved games in a moment. Can I just stay with this top paragraph here, where you've got a game that is being played outside of Perth and the rules are acceptable to the Commission? Did you consider that you were then obliged to approve the game?
Yes.
And would that have included even if the game amounted to a poker machine?
Oh, no.
Now, in terms of the rules, working out that the rules were acceptable to the Commission in this first example, how did you ascertain what the rules of the game were as opposed to its features?
Well, look, whenever these papers were brought to the Commission, then that work around what was being asked of us was done by officers. Obviously, submissions from Crown themselves, which had to be technical submissions, and officers would review them and give a paper that told the Commission what the change was about and how it worked. We often asked for a demonstration, so we got an understanding of what a difference was between, the rules as approved or a changed rule and so on. So none of us were experts on games or of this nature, so we acted on advice from officers that didn't do all that review work.
All right, can we just take an example so I can understand what the process was? If we go to this document, should not be put on the public screen, please. Agenda papers for the meeting on 23 October 2018, GWC.002.0016.0256, and we go to page 0087. Now, this is an example. We've got two games that are approval in principle is being sought from the GWC. One is called Casino Cruise and the other is called Mighty Coin Wealthy Tiger. And there is actually, it doesn't appear any analysis or guidance from the department here. There's just a recommendation that the Commission determine whether to approve in principle. You see that?
Yep.
Yeah. Now, if we just look at
But
this...
there is a process. So the Commission would get a proposal. They would look at the game normally through a real-time simulation, what the game would look like. They'd be told whether the game was consistent with games previously, so generally change of iconography, but based on the same game that existed prior. They would agree in principle. They would then be sent to a certifying agency who would then receive the actual game as it was manufactured and certify that it was consistent with the standards, the national standards and the standards the state applies, and then that would come back as with a certification certificate saying that it is compliant. So in those circumstances, and then of course these approvals are always reversible, so that the games would then be audited against those standards and certification. And if there was a breach of performance in the game, then obviously that would show up in the audit process, and then either approval could be reversed or a change of game. So not every game was approved. Just on prima facie, the commissioners had concerns about how the game, actually looked. Of course, they were checked by officers that they met our guidelines, and Crown were experienced in presenting games. They had to contract specialist game developers for our standards.
So let me just see if I can distill a couple of things from that answer that you gave. If we go back to the briefing paper and the table that I showed you, at 9656, I think it is. I can read out that. Thank you. So that table there, just show Mr. Ord the table. When you talked about the accredited testing facility, in effect assessing and then providing a report on a new game before it was approved, was the testing authority assessing whether the machine met the criteria in the right-hand column
Yeah, that was my understanding.
and ensuring that it didn't meet
Breach
the
the-
requirements of a poker machine in the left-hand column.
That's right.
And did that inform the GWC's assessment of whether or not the rules of a particular game were acceptable?
The certification process?
Yes.
Yes.
So the GWC was in effect treating these items in the table as if they were or bore upon the rules of the game.
Yes, that they would be brought to the Commission by Crown having already been subject to the specifications being given to the game developer. So if you like, the process would be Crown had a number of contracted game developers, not many, that were prepared to develop games for EGMs. They would give a sample, we would look at the sample, give a view that it could be approved subject to its certification. I'm sorry, I've got to turn this off. And that following that certification, then the Gaming Commission would be informed that the game had been signed off and could go into production or be introduced. And then there was a follow-up audit to ensure that the actual outcome met the standards that were certified.
All right, so if we come back to our specific example in the agenda papers for 23 October 2018 at page 0087, item 6.4, over the page we've got the first game, which is Casino Cruise Jackpots. And this is a PowerPoint presentation that Crown comes along and gives the GWC in meeting.
Yep.
Very typical way in which games were considered for approval by the GWC.
Yes.
And if we go over to page 0090, there's an explanation of the game in broad terms. Yes?
Yes.
And continuing over to 0091. And as was evident on the previous page, usually they play you a video which shows you the game actually being played.
Yes.
Yeah. And so once you had the testing, you would have had the testing facilities report on the game at this point?
No, because these were, if you like, software examples of it, the testing lab would approve the final production program, the algorithms that would go into the machine. So this was not, you couldn't do it, you'd have to have a gaming machine to do it, to show the exact one. So there was another step. It's why the games were agreed in principle, but subject to the certifiable model.
So in a situation where you're dealing with a game that is played in other casinos outside of Perth, and the accredited tester tells you ultimately that it meets the criteria for an electronic gaming machine in Western Australia, does the GWC have any other discretion it exercises or takes any other consideration into account for approving the game? Or is it sufficient that you've got the accreditation from the facility telling you that it's not a poker machine?
Yes, we took it that the certifying entity that certified the game met the, that it met the statutory requirements and therefore could be signed off as a game. That's why it was formally certified. Right. And they are licensed by national body.
Now coming back to the briefing paper, DLG 800100459601 at 9656, the second paragraph is in that different position where you've got a game that's not played in another casino, and then the Commission has a discretion whether or not to approve the game if the rules are acceptable and it is not considered to be a poker machine. So in that scenario where it's not played outside of Perth Casino. It's a new game, unique to Perth, and the testing facility has told you it's not a poker machine. What other considerations does GWC take into account before deciding whether or not to approve the game?
During my time, most of the games were simply a replacement for a game that had already been existing. They wanted to refresh the look and so on. So
A variation.
A variation, essentially. When there was something a bit different, and that tended to be games that had more features in it, and there were a few new games that had new features, then the Commission, considered whether those features were such that they had any concerns about it. Generally, they were more engagement with the game, free games and things like that, which overall they saw as relatively benign.
Are you talking about games that were variations of earlier ones or games that were completely new?
Games that were new for an EGM. I said where that change was happening was from relatively simple push and play single runs, so that was sort of a simple run, to one which had additional features in it that enable, like bonus plays and all these sort of additional features, and they were becoming more prevalent as new games more generally.
All right, so can I just ask you to answer this question quite succinctly and directly? If you've got a new game not played outside of Perth Casino before, it's unique to Perth Casino if it's introduced.
Mm-hmm.
The testing facilities told you it's not certified that it's not a poker machine. What are the considerations, the factors that the GWC takes into account in deciding whether or not to approve that game?
Well, they considered whether there was an arguable case why the game should be introduced, and secondly, did they think that the game itself would, would pose any particular risk, I guess, to the user.
In what way? What were the sort of things you looked for?
Well, people asked about, or members considered whether they thought a particular game, might have some, or one of the discussions was the increasing amount of games that had Asian or Chinese iconography in them, and whether that was particularly focused on a particular catchment group. So we were concerned about, what you call the psychological connection between imagery and the potential of a particular customer of Crown.
Targeting consumer groups.
Yeah.
And the addictive qualities or characteristics potentially of a machine, was that something that members looked at?
Certainly we discussed whether there was anything particularly different to this game that might think that it would become more attractive to play it. But overall, there was very little variation, honestly, in between what we already had approved and the few new games that came on. So they had a few more features, but not a lot.
But when you say looking to see whether it would become more attractive to players, you mean to the point where they would become addicted?
We didn't consider that addiction was a likely outcome, and there are other mechanisms to deal with people who might be on the machine for a long period of time. So we did some work. One of the things Mr. Connolly brought back from one of his trips was around an intervention software in South Australia which could track people's time on machine. And we approached Crown and said, could they introduce the software here? And we believe that more effective mechanism would know how long people were on a particular machine in terms of addictiveness, and flag a directive to a responsible gaming officer. So they're already required to monitor people's time on machine and approach them if that time was excessive. and offer them a time-out break, encourage them to go home, all sorts of things. In this case, we wanted a digital intervention that could do that. They weren't able to do it at the time with the Advantage software they had, but they committed to review to see whether the software could be updated to do that.
Can I just make sure I haven't misunderstood some of the evidence you have just given to the Commission? Is it the case that the GWC did not consider it a likely outcome that approving a new game to be played on an EGM would result in addiction?
We didn't consider that there was any likelihood of greater addiction than the one that existed with the current program. So we were more interested in trying to find mechanisms to potentially divert people from spending excessive time on the machines.
And the reason you were focused on that was because that recognised the addictive characteristics of EGMs generally. Is that right?
Yep.
Now, you were talking about the bulk of the approval work a moment ago being in relation to the variations of existing games rather than approving wholly new games at Perth Casino. We're talking about EGMs here, to be played on EGMs. Did you understand that essentially most EGMs, most new games played on EGMs were approved as variations to either Video Bingo or Arashinko?
I'm not sure that my understanding was exactly that, but yes, that they derived from a common base.
So if we go back to our example of the Casino Cruise Jackpots game that I was showing you a moment ago, page 0091. If we go back to 0089, please. Sorry, 0090. And you see there, it describes Casino Cruise as being a derivative of the approved game of Mystic Wolf. That's an example of being asked to approve a variation of an existing game, and I think Mystic Wolf itself is a derivative of Video Bingo. How did the GWC during your time distinguish between a game that was entirely new and a game that was a variation of an existing one?
I understood that we were informed of the process by which the game had been developed, and Crown coming in would give us a background to the game, part of the reason why they wished to introduce this new game and who the developer was and what they were hoping as an experience for the player that came from it. So there was, as said, apart from some additional features around free play and so on, and more player interaction, there wasn't a lot of difference between the historic games and new games that have been introduced.
Well, what do you mean by that? Not a lot of difference?
Well, as I said, they looked like these kind of screens with tiles and rotations, and its player feature, for instance, a particular jackpot feature or a free play feature that was being added.
So just coming back to my question, when we're looking at about new games to be played on, I'll rephrase that, games to be played on EGMs that required approval, how did you distinguish between a new game and a variation of an existing game?
Well, we were just simply informed of that by technical officers that were assessing these submissions.
Who are you referring to, technical officers?
Well, department staff, Mr. Connolly himself, who was, an expert in this area, and Crown submissions, and then, as I said, it got determined through the certification process that it was compliant.
Well, that it wasn't a poker machine.
Yes.
But that didn't tell you whether it was a new game or a variation of an existing game, did it?
No, not necessarily.
And why do you say Mr. Connolly was an expert in EGMs?
Well, because he had spent a long time in the role of being the chief casino officer, and had spent a lot of time studying the features of these particular games. It was a big part of our, as you said, it was a large part of our business.
Were there any policies or procedures that the GWC had developed to distinguish between approving a new game on the one hand and approving a variation to an existing game on the other?
No, I don't believe so.
Was the approach to approving a variation to an existing game the same as or different from the approach to approving a new game?
I mean, the members were, in getting these presentations, were keen to understand how the game was played, you know, how it actually manifested itself, to ensure it was consistent with what their expectation of an EGM. They went out to casino as a group on several occasions to actually see the actual real artefact, because getting it on a screen in a meeting room is, you know, difficult to sense the way in which the game plays out. So, you know, that's essentially, they did knock some games back because they didn't like the presentation of the way the game played, and they were concerned either that they thought it would start to look too much like a spinning reel demonstration or thing, and or they were concerned about the refresh times and to whether that truly reflected a 5-second standard. So while we could assess them on the technical framework, the commissioners themselves were still very concerned and involved in making sure that they could raise any concerns they had and that they would be applied to Crown before we went into the game development and certification stage. So some of them were just knocked out on the basis they didn't like the game look.
Before it went to accreditation?
Yeah, they were never developed formally as a game after that.
And is that whether it was a variation on an existing game or only when it was a new game, or did it apply to both situations?
I think it was mostly new game development that was of concern. The variations did tend to be to simply a colour palette change.
Okay, so when we come to variations and you've got the testing facility saying it's not a poker machine, were there any factors in addition to that that GWC took into account when deciding whether or not to approve a variation?
Well, the factors that they were concerned about is, as I said, they often talked about whether the game, you know, how the game presented and whether there was any concerns that it, you know, could represent some change in the neutrality of the game, if you like. Is there something that changes this in such a way that it's not what we or the consumer would have been expecting?
Didn't you say a moment ago, though, that that was predominantly in the area of new games?
Yes. Yeah.
So when we're talking about variations, you've got an existing approved game, Crown comes along with a variation to that game, testing facility says it's not a poker machine. Is it automatically approved, or is there a discretion that the GWC has to nevertheless reject that game?
But they could have rejected. They tended not to, on the basis that they understood that Crown as an operating business needed to refresh the product, you know, on a regular cycle, and that the, you know, the program of them coming in for refreshes were consistent with what they were expecting.
All right, so if the GWC could have rejected a variation to an existing game that was not a poker machine, what was the basis upon which it could do that?
Well, I think Crown took the view that regardless of whether they would challenge such a thing if it wasn't necessarily in the statutes, that they could reject it. And coming back to some of the previous matters we've looked at, my view is Crown was very interested to know whether the Commission had any concerns about the games they were putting up. So when concerns were raised, they did appear to try to address it with the game developers.
What sort of concerns are we talking about in relation to variations?
Well, it probably was just the nature of the iconography.
The symbols.
Yeah.
Now, can I take you forward to 2019, and you recall the topic of when the appendix to the National Gaming Machine Standard was changed at the request of Crown.
Mm-hmm. Now,
you received this letter from Josh Preston of Crown Perth on the 14th, or dated the 14th of November 2018. That's CRW.008.042.8653. Now, this precedes the application in 2019 or the submission requesting an amendment to the appendix. And at this point in late 2018, Mr. Preston is setting out the RSG framework for Crown Perth. And at the very beginning, it refers to a recent telephone discussion between you and Mr. Preston, as well as a request from the GWC to provide a detailed submission on RSG and so forth. Was this a request that the GWC made as a consequence of recommendations coming out of the 6th VCGLR review of the Melbourne casino operator?
Yes, in our, I think, meeting prior to this, they had raised concerns that they wanted to see what Crown was doing to improve their RSG activities. So based on that request of me, I rang Mr. Preston and said the Gaming Commission would like, and gave him an outline of what they would like in a submission. So they wanted a submission and then an opportunity to engage with him.
Was it the case that the VCGLR recommendations coming out of that 6th review caused the GWC to reflect on whether it had been to that point placing sufficient emphasis in its oversight on RSG issues?
From the time I took over, there was an increase, I'd say a gradual increase in concern around responsible gaming matters more generally by all members. And that led to a number of things, including, visits on site. Even one of the commissioners went and did the Crown training course and so on. So, yes, there was increasing desire to see how Crown was improving their RSG things. Now, there's, as you know, a lot of debate in Parliament at the time from from the member Wilkie, who was raising concerns about responsible gambling, and we were trying to reflect on that to ensure that Crown was best practice.
So it wasn't the VCGLR review that caused GWC to make this request, but rather interest in the question of or the issue of RSG that had arisen elsewhere.
Well, all these things reinforce themselves. So, as I said, they had been growing concerned about RSG and were keen to see the response. We had two members on the commission at that time who were particularly focused on the issue, and we were trying to respond to member interest to increase that. So, yes, I think this was related to the Victorian outcome specifically to ask for a formal presentation from Crown, but we had been engaging with Crown long before this.
Right, if we go over the page, please, to 8654 and the 4th dot point.
Do you have much more on this?
I'll just finish this question and then pause. It's actually got two components, but it'll be very brief, Commissioner. Do you see the significant financial commitment and investment into RSG over the past decade, with the annual RSG expenditure now exceeding $1 million?
Yes.
did at the time you consider that to be sufficient expenditure on RSG relative to the revenue from EGMs that Crown was receiving each year?
I didn't have a view on that, rather that they were reporting they were increasing their expenditure.
Right. Was the sufficiency of that amount something that was considered or discussed by the GWC at that time?
No.
That's a convenient point then.
Thank you. Mr Ord, we will take lunch now. We will resume again at 2 p.m. If you could be back in time to recommence. And we will now adjourn till 2 p.m. Thank you.
All rise.